Well, then I would like to welcome you to this event, to the folks who are in the room and the folks who are online. My name is Kathy Hessler. I'm the Assistant Dean for the Animal Law Program here at GW Law School. And it's my privilege and honor to be able to introduce Brooke Detkoff, who's an associate at Richmond Law and Policy, who's going to be talking with us today on a really interesting topic. We're hoping that we get to learn a sort of new tool in the toolkit for working on animal welfare issues. So, with no further ado, well, help me welcome Brooke.
Thanks so much, Kathy, and thanks to the Animal Legal Education Initiative for sponsoring this talk today. It's really wonderful to be here. So as Kathy mentioned, my name is Brooke Detkoff, and I'm an Animal Welfare Fellow and Associate at Richmond Law and Policy. My work largely uses complex civil litigation, consumer protection statutes, and one particular consumer protection statute called the CPPA, the Consumer Protection Procedures Act. That's a DC-specific statute to bring claims on behalf of nonprofits to challenge corporate and animal agribusiness humane washing. My primary interest has been aquaculture and aquatic fish farming. So I've been working on advocating specifically for farmed aquatic animals, combating the harms resulting from industrial aquaculture, and pardon the pun, although there will probably be a few more throughout this presentation, using our litigation really as a vehicle to help consumers sift through a sea of misinformation surrounding aquatic animals, the harms resulting from aquatic animal factory farming, and the impacts on communities where these aquaculture facilities are located. So before we get into the actual presentation itself, I wanted to take a moment to just kind of ground where our discussion is going to be situated today. So attorneys, and particularly attorneys advocating on behalf of farmed animals, which is most of the work that the folks at RLP and that I focus on, have to face a lot of issues moving through their litigation and their advocacy work. As many of you may be aware, animal agribusiness, whether land or water-based, has been incredibly successful at foreclosing a lot of the traditional pathways for litigation that animal advocates, and particularly farmed animal advocates, would have hoped to use to advocate on behalf of farmed animals. Some of these examples that you may be familiar with include exemptions to state anti-cruelty legislation for farmed animals, ag-gag laws, the recent introduction of the EATS Act, which seeks to undo truly decades of work by farmed animal advocates who were pushing the envelope to really get states to introduce legislation enacting really bare minimum protections for farmed animals. And we see this even more frequently. As those of you who may be familiar with this type of work, familiar with this industry, farmed animal advocates are very frequently working against an industry or on the opposite side of an industry that has incredible political and public power and seemingly endless amount of resources, and really a true stubbornness to ensure that any advocacy effort to influence a minimal amount of protection for farmed animals goes challenged. Given this, farmed animal advocacy requires a willingness often to test novel legal arguments, to go up against or set existing precedent, and the resilience to face the inevitable losses that we ultimately do. In short, farmed animal advocates have to be creative. Attorneys working in farmed animal welfare are often class action attorneys, they're environmental attorneys, they're criminal attorneys, and the legal strategies that they use to advocate on behalf of farmed animals are equally as varied. So today's talk will focus on looking at one such creative strategy, the National Advertising Division, an alternative forum for challenging humane washing made by animal agriculture. So you heard me mention the word humane washing a couple times. I wanted to set the stage and go into exactly what humane washing is. So humane washing is a form of deceptive marketing, something like greenwashing or pinkwashing, which occurs when CAFOs or animal agriculture knowingly weaponize consumer concerns to increase profit margins by labeling, marketing, or advertising their animal products with particular animal raising claims or humane style claims that are ultimately deceptive or not true. Consumers are often unable to discover the truth of these types of claims for themselves. And for those of you who benefit from concrete definitions, the definition included on this slide is from Farm Forward, an organization that has done significant work to poll consumer perception on animal raising claims and humane style claims that appear on animal products and bring to light the dangers and confusion inherent in humane washing. So I've included here in the second bullet point a few examples of some of the common types of humane washing claims we see coming from animal agriculture. I just wanted to run through an example like cage-free. So cage-free is a claim that you will often see on egg products, and it refers to the conditions under which the hens who laid the eggs are raised. A consumer standing in a grocery aisle might see an egg package labeled with the claim cage-free, and it would conjure images that the chickens who laid those eggs are able to go outdoors, roam on pasture, express natural chicken behaviors like pecking, foraging, roosting, dust bathing. They can walk through grass, they can walk through dirt, and that might be some of the images that a consumer seeing this type of claim would imagine in their head as they're reading an egg package. Unfortunately, a claim like cage-free is entirely defined by the producer who puts that claim on the package. So there's no set legal definition for a claim like cage-free, and there's no mandatory review in many circumstances for a claim like cage-free. What a term like cage-free generally means is that the chickens raised at the facility where they are laying their eggs are not confined in battery cages. Often they're still confined indoors for their entire lives. They'll never see sunshine, they'll never go on grass, they will never have access to dirt, and they will never be able to express natural behaviors. They're often allocated something like a square foot of space per bird, which is about, for those of you who are difficult at visualizing space, as I am, it's about the size of a standard sheet of printer paper. So that's what's actually going on at these facilities that will then label their eggs as cage-free. So how is this possible? Well, first, as I mentioned, there's no legal definitions for many of these animal raising claims. The second is even when there are legal definitions set for these animal raising claims, the agency charged with reviewing the substantiation for these claims, the USDA, and in particular the Food Safety and Inspection Services, which is FSIS, a subdivision of the USDA, is not actually adequately reviewing substantiation of the claims at issue. So under the Poultry Products Inspection Act, the PPIA, and the Federal Meat Inspection Act, USDA FSIS has to mandatorily review certain on-label animal raising claims made by meat producers. But this mandated on-label review only applies to animal meat products. It does not apply to, for example, dairy products. It does not apply to egg products. And it only applies to on-label representations. So representations made via a website, representations on a billboard, none of those are subject to mandatory review. So when we ask the question of how do these claims proliferate, how is the industry able to get away with this, it's really a twofold problem, and the problem is no set legal definition, combined with the fact that even when there is some type of guidance on point, the review for these claims is not actually happening the way it should. So, even when review is mandatory pursuant to the PPIA and the FMIA, we know that USDA is not adequately reviewing the claims at issue. Animal Welfare Institute recently released a report where they evaluated 100 different producers who were making on-label humane style claims. These producers would have been required under the PPIA and the FMIA to have USDA FSIS review these claims to ensure that they were adequately substantiated. However, the results of this survey out of 100 producers showed that for 50% of the producers making these on-label humane style claims, there was no application on file with FSIS at all. For 6% of all of the claims challenged, there was an application on file, but that application actually contained no substantiation for the claims made on label. And then for an additional 29% of on-label claims that were reviewed, there was some substantiation, but the substantiation was inadequate to support the claims that were being made by those producers. So this is a real problem when we only have certain claims that are subject to mandatory government review and are subject to mandated legal definitions under current existing regulations. And what actually happens is this review is not being adequately addressed. So as a result, a group of senators had written a letter asking USDA to update its practices and to actually ensure that these claims are substantiated. You can see an excerpt of this letter here. Feel free not to parse through all the language, but I did think it was important to draw attention to the fact that people are increasingly aware of this issue, and they are increasingly aware that USDA is not taking its regulatory responsibility as strictly as it should be under these circumstances. So why does it matter? We've talked a lot about how the problem of humane washing occurs, what humane washing is, but why ultimately is this something that animal advocates and farmed animal advocates should be focusing on? So there's a growing and continually growing body of consumer perception research that shows that consumers, including consumers who purchase animal products, care about improving farmed animal welfare and are willing to purchase animal products, will seek out animal products, and will pay more for those products that contain on-package or alternative advertising that says that those products are produced in a more humane manner than conventional industry practice. I think this should give everybody in this room and attending virtually a little bit of hope, because we do know that the general population cares about these issues and wants to use their preferential purchasing power to make as much change as they can when shopping in the grocery store. So we know that when consumers are standing in a grocery aisle, that for many, they want to leverage this power, and they want to use their preferential purchasing power to support companies that align with their ethical concerns, including improved farm animal welfare. And they will in fact choose the products with claims like cage-free over competing products without those claims. But this choice is truly impossible if consumers are acting on false and misleading assurances. And in many cases, consumers don't even realize that there's a potential for deception. For example, Farm Forward's 2022 Consumer Perception Survey found that while 77% of American shoppers said that they know where their animal food products come from, the same percentage of polled consumers, 78% of those, said that they believed or they would be concerned if they learned that their animal products come from factory farms. Obviously, there's a disconnect there because most animal products are sourced from animals that are raised on factory farms. So there's really a concern here where consumers just aren't able to even realize that they are being deceived by a lot of these humane washing claims. I think this example highlights exactly why humane washing diminishes the efficacy of our advocacy as well. It makes our jobs as farmed animal advocates infinitely harder because we now have to fight for both improved production practices and practices that will improve animal welfare for the animals living in these conditions. And we also have to contend with a widely held and often deliberately cultivated false narrative that many farmed animals are already treated humanely. And consumers actually can't determine the truth of these claims for themselves. Tracing a supply chain back from the egg that you purchase in a grocery store to the hen that laid that egg and to the facility where that hen lives is nearly impossible. I don't think this is a controversial statement, but as a normative matter, it shouldn't be more profitable to lie about your production practices than it should be to be honest about what you're actually doing. So traditionally, when we challenge humane washing claims through litigation, we use two primary mechanisms. The first is a consumer class action made of consumer purchasers of the product that we would allege is misleadingly advertised. And the second is something that I referenced before, a nonprofit action generally brought under the Consumer Protection Procedures Act, the CPPA, which alleges similar causes of action, arguing that the claims or the products are deceptively advertised. So these are the two primary vehicles that have been traditionally used by litigators challenging greenwashing, and humane washing, but they are not always the most viable, and they could not be viable for factual, procedural, or substantive reasons. So to give a little bit of overview of some of the problems that we face when we use these traditional forms of litigation to combat humane washing, the first is something we had just discussed, which is this information gap. So this information gap exists for consumers, but it also exists for litigators. It's often incredibly difficult for a litigator who sees these types of claims, sees the on-package and or other forms of advertising claims, to then determine what the actual practices at that farm are in order to prove that those claims are deceptive. So we know quite a bit of information about the industry generally, but finding out about specific practices at a specific producer is very difficult to do. And there's a couple tools that folks working in humane washing or challenging humane washing will use to try to find out what the actual on-farm practices are. These might include things like undercover investigations, relying on our partner animal advocacy organizations who are able to get in the door and find out exactly. I guess we'll pause a second for the sirens.
Instead of being in DC.
Right? All right. So the undercover investigations, but often it's not possible to get into these facilities. The investigations themselves are expensive. They take quite a bit of time. And as you may be aware, and we discussed previously, the ag-gag laws can pose an issue for these types of investigations. We can also find out what's going on the farms through FOIA requests to learn if that particular producer has violated, for example, good commercial poultry production practices. USDA under the PPIA and FMIA is required to inspect some of these facilities, so often this is another tool to find out what's exactly going on at these facilities. We can use drone surveillance in our modern world, or backward supply chain tracing, which is what I described previously. But sometimes none of these avenues are fruitful, and we're still left with a gap between the claims that the producer is making, what we know about the industry generally, and what is actually going on that specific producer's farm. Preemption is also an issue. So as mentioned, pursuant to the PPIA and FMIA, there are certain on-label animal raising claims that must be reviewed by the USDA FSIS. The review itself is not adequate, but when the review occurs, courts have consistently held that private actions are preempted. So there is no avenue if USDA FSIS has reviewed an on-label animal raising claim for the certain products I described before to bring an action by private enforcement. That action would be preempted. There is a narrow exception that hasn't really been tested yet, but I would like to draw attention to. If on the facts, it's apparent that USDA FSIS, so like many of those examples we discussed before, producers who actually have no application packet on file at all, if it's clear that FSIS did not actually review the label at issue. So on the facts, there's no evidence that they looked at the given claims, there's no application packet, not in those cases where they had failed to substantiate the claims adequately, but then on the facts, it might be possible to escape the preemption argument. When we bring these cases as class actions, we also have to satisfy Rule 23 prerequisites, which can be incredibly difficult. So since we are often preempted from challenging on-label representations, we instead look at other forms of humane washing advertising, claims that appear online, on billboards, maybe in-store signage. The difficulty with this and with satisfying Rule 23 prerequisites when you bring a claim on this basis is that we run into problems with class-wide exposure, which translates to problems with commonality and typicality. So a lot of courts and a lot of jurisdictions now require that every purchaser of the products, in order to certify a consumer products class action for humane washing claims, would have had to have seen and looked at the representations before purchasing the product. If you have a billboard or an online advertisement, it's often incredibly difficult to prove that every member of the class would have necessarily seen the representations at issue, because honestly, most people are not pulling out their phone in the grocery store aisle, they're not following a direction to go to this website and then scrolling through that producer's website and identifying the claims at issue. Whereas with an on-label claim, which again faces the issue of preemption, we necessarily know that every purchaser of that product saw the label, looked at it, and saw the claims at issue. Standing also poses another potential barrier. So this varies for jurisdiction for class representatives, but increasingly a number of jurisdictions are requiring that for a multi-state class, you have a named class representative from each state in which you are asserting a claim under that state's consumer protection law. So to give an example for this, if you have a nationwide class, you argue that this is deceptive under every state consumer protection law, you would need 50 named representatives or 50 named plaintiffs in order to successfully bring that as a class action. Class actions were designed in part in order to avoid the difficulties inherent with bringing multiple plaintiffs into a single litigation. But standing, when interpreted this way, obviously just resurrects those issues, and it's just incredibly difficult to find, and for 50 named plaintiffs to come forward from each individual state and say, I have been deceived. So standing is also an issue for injunctive relief and discontinuance of the humane washing claims. Often when you think of this type of litigation, the relief that we think we would be seeking is for the producer or the factory, the animal agriculture company, to stop making the humane washing claims at issue, to remove them from the package, to remove them from the label, to take them off the billboards where they're listed, so that consumers are no longer misled by the claims that they are making. The courts have consistently held, and there are a few exceptions, that when a consumer brings these claims on behalf of a class, and the claims are based on misleading advertising for a product, that consumer has no standing to seek injunctive relief. And it's kind of a wonky argument to wrap your head around, but the argument goes like this, that because that consumer is now aware, since they are bringing this litigation, that the claims are false, there's no threat of future injury, and therefore they don't have standing for an injunction. I heard a bit of laughter here. Yes, this necessarily means that a consumer plaintiff does not ever have standing to seek an injunction because they are always necessarily apprised of the deception by the time they're bringing the lawsuit. And standing is nearly impossible for third-party certifications. So third-party certifications are a particularly nefarious form of humane washing and greenwashing because they are often from third parties. They give an independent sort of legitimacy to these claims that companies are making, which makes it even more deceptive for consumers seeing a third-party certifier's logo on the product that they're purchasing. But it's very incredibly difficult for an individual to have standing to challenge a third-party certifier. Puffery and aspirational claims. So humane claims that are not concrete, that are not definitive enough, that are maybe more of a, we're striving toward this outcome, or we're trying to do our best, we're investing, those could sometimes fall under the category of puffery, in which case they would be unactionable, which makes it becomes a fine line of crafting language that is close enough to puffery so that it would be non-actionable, but is still deceptive to consumers. So this raises the question, how can we effectively advocate for consumers, combat humane washing, and advocate for farmed animals when litigation is not viable in these cases? And that's when we turn to the NAD. So the NAD, or the National Advertising Division, is an industry self-regulation forum that is designed to build consumer trust in advertising and support fair competition. NAD and its corollary, the National Advertising Review Board, or the NARB, have the single largest body of advertising law in the country. This is essentially all this forum does, is review false and deceptive advertising. So they are truly industry experts and have substantial expertise in evaluating the truthfulness of advertising. Challenges before the NAD can be brought by almost anyone. They can be brought by businesses, trade associations, individual consumers, nonprofits, or the NAD itself, sua sponte. And as mentioned, this is traditionally a forum for industry to air its grievances against another form of industry. So the traditional challenge that we would see would be something like Verizon versus T-Mobile, T-Mobile versus Verizon. But because NAD is so focused on preventing deception and their true focus is on curing misleading advertising and policing the industry itself, they do allow alternative bodies to bring these claims. So it's a remarkably open forum. So what exactly does an NAD challenge look like? NAD and NARB have their own procedural rules developed by BBB. You can think of these as the analog to the Federal Rules of Civil Procedure, the NAD Rules of Procedure, and much like the courts, NAD and NARB have developed a series of procedural and substantive rules that govern disputes. NAD serves as the trial level body in these actions to adjudicate advertising challenges, and appeals go to the NARB. There's a few types of ways that you can bring an NAD challenge. So the first is a standard case. That's what our case examples later in this presentation will focus on. That's the traditional mechanism for bringing an NAD challenge. The other is what's called a fast track SWIFT, single well-defined issue. And this is reserved for challenges where you're really targeting one piece of advertising, one misleading claim, and the evidence is not difficult to decipher. It doesn't require scientific expertise. It doesn't require experts battling it out to determine the legitimacy of the evidence presented. It doesn't require complex consumer protection evidence. It's really reserved for those cases that can be decided relatively simply based on the expressed language of the claim itself. The exact opposite of this would be the complex track. That's reserved for cases where there's a ton of claims at issue and maybe they fall into multiple buckets. So you have environmental claims, animal welfare claims, you have labor claims as well. And the claims themselves, in order to prove or disprove, would require highly technical substantiation or substantiation that might require expert evidence. So for those of you who are litigating in the modern era, you will be pleased to know that the NAD requires electronic filing of all documents. And they also recognize and encourage non-industry bodies in order to bring these types of claims. And one of the ways you can see this encouragement is really the discretionary waiver of filing fees for economic hardship. So it is a discretionary process, but they do waive filing fees in certain circumstances for organizations that are able to prove that they have a viable claim, that they would like to bring this claim before they NAD, and that paying the usual filing fees would be a bit of a hardship for them. So as mentioned, participation in the NAD process is air quote voluntary. So an advertiser does not actually have to agree to participate in the process. It's an industry self-regulation forum. They can decline to participate. It's not a court order. It doesn't have enforcement authority. That said, NAD takes this process very seriously, and most of the industry does as well. So declining to participate in the NAD process could result in referral to the FTC. And given that NAD has developed a significant expertise on these claims, that they are really the single largest body of advertising law in the country, FTC takes NAD referrals very seriously. So here's a fun slide that walks us through the NAD process from the beginning of the challenge letter, which is the analog to a litigation complaint, all the way up through appeal. Following the filing of the challenge letter, the advertiser will have the opportunity to submit its response and any supporting evidence. Challenger can then choose to reply, and advertiser has one more opportunity to respond. So I do want to note that while NAD focuses on the substance and merits of the argument at hand. A procedural defect, generally speaking, throughout any of these forms of briefing, will not make or break a challenge, but may just result in a request that the defect be corrected. The parties are afforded the flexibility to agree to extensions privately before seeking NAD approval, which is often granted. And overall, because the process is significantly less adversarial than traditional litigation, there is more cooperation among the parties, a readier exchange of information that otherwise, as we discussed previously, might prevent a plaintiff from really knowing what's going on at the facilities that they're challenging. And it makes overall for a more cooperative process where the parties are really trying to ensure that the advertising at issue is as accurate and honest as possible. So following the conclusion of all briefing, NAD will generally hold a hearing on these issues. These hearings can be held ex parte with each party individually. And because NAD is focused not on just stopping false and misleading advertising in order to build consumer trust, but also informing the industry on best practices, these hearings present a real opportunity to discuss what the functional outcome of a decision in the given case would require. So NAD takes great care to say, okay, if we decide this way in a given case, what does that outcome look like for providing guidance to advertisers in the future? Would it be unworkable? would on the ground this be practicable? And that's something that you don't often see in court, because courts are often precluded from focusing on these functional or normative factors because they're bound by precedent. NAD obviously has its body of precedent, but they are also focused on really seeing how their decisions work out in practice. So following the hearing, NAD will then issue a decision. For those of you who currently litigate something or are interested in litigation, something I do want to draw your attention to, and I've included times here for each of the steps, not because it's useful to memorize, all of this is written down as mentioned in procedural rules, but because you can really clearly see how quick this process is. From beginning to end, a standard track challenge, from the filing of the challenge letter itself to ultimate disposition of the case at NAD, not including appeal, could take approximately a year, could take a little bit longer than that, a little bit less, but it's much quicker and moves much faster than traditional litigation does. So I just wanted to draw a comparison between the traditional forms of litigation used to combat humane washing and NAD actions, and really talk about some of the differences between the two. So, benefits over traditional litigation. In NAD actions, the burden is firmly placed on the advertiser to substantiate each and every claim they make, including those claims that they did not intend to convey, but which may be implied from the express claims at issue. So this gets us into the second point on this slide. NAD challenges include both express, the actual language that advertiser is making, and implied claims, any claims that naturally follow from those claims. So this is a pretty unique opportunity to say that, okay, the language says one thing, but the language is also conveying a broader message about your animal care practices, about how you're treating the animals under your care, than what perhaps the actual language says. And that's a pretty unique opportunity. As mentioned, NAD does not have preemption. So NAD does not automatically defer or does not hold that their challenges are preempted because an advertiser has gone through the mandatory FSIS pre-label approval review. Instead of automatic preemption, NAD applies a series of deference factors, and these deference factors are pretty exacting. We'll talk about them a little bit later through the case examples, but there's nothing here that would prevent a challenger from making a claim to a misleading on-package representation that did in fact undergo mandatory FSIS review. No standing requirements. So you might have gathered this from the fact that challengers can be individual consumers, they can be other industry trade groups, they can be nonprofit organizations, but there's no standing requirement to bring an NAD challenge. You don't have to actually be misled by the advertising, you don't have to have relied on the advertising at issue, you just really have to say, hey, this is misleading and here's why. So that's often something that we run into in traditional litigation that's not an issue with the NAD actions. NAD has a higher bar for puffery. So this is a little bit self-explanatory, but the line for what constitutes puffery at the NAD is just about one step higher than what courts would view as puffery or non-actionable. So it really does allow you to go after more claims that are still probably deceiving consumers, even if they are couched in language that is not as concrete or definitive. Something else that is unique to the NAD forum is that aspirational claims, so forward-looking claims, claims about goals or commitments or ideas, still require substantiation. So an advertiser cannot just say, whoa, this is something that we were interested in reviewing or interested in pursuing, but we just haven't gotten there yet. And we're working toward achieving that goal, but we don't have to provide enough evidence to show that we've actually achieved that goal yet because the claim is forward-looking and aspirational. But under NAD precedent, aspirational claims still require significant substantiation. That substantiation must be tied to the type and scope of claim at issue. As mentioned, the speed of the decision compared to traditional litigation the NAD process is significantly faster. It's more cooperative. NAD is probably the foremost expert on these advertising claims, so you really have the benefit of talking to folks who work in marketing, who work in advertising, who know what consumers think and know what they're taking away from messaging that is potentially deceptive. FTC referral. And we discussed this a little bit previously, but again, one of the issues with traditional litigation is that consumer plaintiffs lack standing to get injunctive relief, which means under consumer class actions brought to challenge humane washing claims, you're really limited to monetary damages. But the traditional remedy at the NAD is always injunctive-esque relief. If NAD decides that a claim is deceptive, their relief is always discontinuance or modification of the claim at issue. So automatically, if you succeed in an NAD challenge, the type of relief that you're going to get is injunctive. The benefit of this is it stops the false advertising and the humane washing in its tracks. No more consumers are going to get misled by the advertising at issue, and the advertiser is forced to take down the misleading claims. So in terms of potential complications, I'm just going to run through these very quickly. NAD has a significant barrier for the dissemination of their decisions. They have a pretty high, they have significant press restrictions for disseminating these decisions. And the reason for this is because traditionally, as mentioned, this is an industry self-regulation forum. So to go back to my example of Verizon versus T-Mobile, NAD does not want Verizon to bring a challenge against T-Mobile and say that T-Mobile's advertising is deceptive, succeed in that challenge, and then turn around and use NAD's decision showing that T-Mobile's advertising was deceptive as a marketing ploy to say why you should choose Verizon over T-Mobile services. So that is kind of their concern. It does make it a little bit more onerous for getting the word out for consumers and for nonprofits bringing these cases, because nonprofits are more interested in the consumer advocacy side of it, the anti-humane washing side of it, and their interests tend to be more aligned with the NAD's interests in protecting consumer choice and ensuring that folks are receiving accurate and honest information. NAD has a significantly high bar for survey reliability. So when you're suggesting what a claim means to consumers and what consumers take away when they view that claim in context, one of the primary things that we will look to for traditional forms of litigation and in the NAD itself is to present survey evidence, to say consumers viewing a cage-free claim think that cage-free means this. But the types of surveys that would pass muster in a traditional court are often insufficient for the NAD. NAD, because they are advertising experts, because they take a look at a lot of these types of claims and are aware that surveys can be modified in accordance with searching for particular results, have a very high threshold for what types of surveys will pass muster. Again, it's a voluntary process, which means the advertiser ultimately does not have to participate, but again, that would often result in referral to the FTC. This is an issue we'll discuss later, but post the CARE decision, NAD has held that there's only minimal really substantiation required to prove that an animal agriculture or factory farm exceeds industry standards for whatever animals that they are raising. Post-decision enforcement and compliance can also be an issue because, again, this process is voluntary. NAD is not an agency. They are not a court of law. They don't have the authority to enforce the modification or discontinuation of the claims at issue. It is truly voluntary and incumbent on the advertiser to do so and agree with their recommendations. So that could be a potential problem for a particularly recalcitrant advertiser. And the last one is varying substantiation depending on the claim. As you will notice, this is included on both a benefit and a potential complication because in certain circumstances, when the substantiation burden is high, it works out wonderfully, and then in other circumstances, when the substantiation burden is a little bit lower, as we'll discuss in this particular CARE case, it could be a little bit harder to prove that the claims in fact are misleading, even when consumers are in fact being misled. So the first case we're going to take a look at, this is Butterball Turkey Products. This was a challenge brought by Animal Outlook, a nonprofit organization that challenged advertising made by Butterball. Butterball is a turkey producer, and they made a number of advertising claims. I'm not going to list them all out here, but we'll group them into buckets. They argued Butterball is a turkey producer whose animal care practices generally comport with industry standard animal care practices. So they're a large-scale industrial factory farm. Their practices are largely conventional. They're not doing anything above and beyond. And Animal Outlook argued that 3 buckets of claims that Butterball made on this basis were deceptive. The first of which were express and implied natural claims. The second of which were express and implied humane claims. And the third were express and implied environmental claims. So turning first to the natural claims, NAD in fact held here that Butterball's natural claims were substantiated. So Butterball made claims like healthy natural turkeys, and these claims were presented with an asterisk that clarified that all natural means minimally processed with no artificial ingredients. So there was and NAD found that this disclosure was relatively prominent on the front of product packaging. It wasn't hidden behind on the back of product packaging. You could really see the asterisk and see exactly where the disclaimer was. AO implied that these natural claims, both the express and implied natural claims, conveyed to consumers that the turkeys have regular access to the outdoors, are given feed without artificial ingredients, are not given drugs, antibiotics, or other forms of biocides in their feed or otherwise, that they are not given during their lives or processing, they're not bred using artificial insemination to produce turkeys who grow up with unnaturally large breasts, that young turkeys and adult turkeys are not macerated while they are alive. And in support of these claims, AO produced a few forms of evidence, the first of which was consumer perception studies regarding consumer understanding of the term natural, FTC guidance on substantiation requirements for the use of the term natural, which does in fact have certain regulatory guidance suggesting definitions for the use of this term, and evidence about Butterball's actual practices, including undercover investigations. NAD, however, found that Butterball's express natural claims were substantiated and that consumers would read this claim, particularly in the context of the prominent disclosure as presented, as referring to the contents of the finished product itself and not speaking to Butterball's farming or overall production practices, how they actually raise the turkeys under their care. So in making this decision, how did NAD come to this conclusion? They relied primarily on FSIS guidance, which was introduced by both parties, on the use of the term natural, on label for poultry products. NAD regularly strives to do what it calls harmonize its decisions with federal guidance. And that guidance comported in this case with Butterball's definition and not the broader interpretation presented by AO. So this could be a bit of a problem in terms of natural claims. When there is federal guidance on point, NAD really does strive to ensure that its decisions are compliant and working together with that guidance in order to create a harmony of industry regulation. Moreover, as mentioned, AO produced survey evidence, and this speaks a little bit to NAD's requirements for what is a successful survey that could be presented and what is sufficiently reliable in terms of survey evidence. NAD found that AO's survey evidence was not reliable in this case because it focused on international rather than American consumers, and the terms polled were not sufficiently similar to the context in which Butterball's natural claim appeared. So the terms polled in the studies that AO had cited referred to the term natural without the asterisk disclaimer, and NAD is highly focused on the context in which these claims appear. So a natural claim without a disclaimer, that's a broad, general, unqualified claim as compared to a natural claim with a disclaimer, which is then modified and limited by the context in which it appears. So Animal Outlook also challenged humane claims. The humane claims at issue included both superlative claims, which we'll cover shortly, and other claims like farmers humanely raise our turkeys every day, commitment to animal care and well-being, zero tolerance policy against any form of animal abuse. It is our responsibility to produce healthy, high-quality turkeys in a responsible way. and we are committed to maintaining the health and well-being of our turkeys. As you can see, a lot of these are couched in what we would traditionally call puffery, committed language that is not necessarily actionable, but which was at issue in this case. So Animal Outlook argued that these claims implied that Butterball turkeys are raised and treated humanely on small family farms where farmers provide individualized and prompt veterinary treatment for the turkeys under their care. They argued that Butterball does not grind up or macerate live birds, that Butterball turkeys, given the advertising at issue, are not raised and confined in overcrowded, unsanitary, and disease-ridden facilities, that the turkeys are never subject to deliberate abuse by the workers, that the turkeys are unconscious at the time of slaughter, and that the turkeys are not bred for excessive weight gain. And in support of these arguments, they provided, again, consumer perception evidence on consumer understanding of the term humane. They also provided reports of Butterball's treatment of its turkeys. So this included undercover investigations, including undercover investigations conducted by the challenger itself, and they provided FOIA documents showing Butterball's non-compliance with good poultry commercial practices, which they argued represented a pattern of deliberate abuse on Butterball turkeys. With the exception of one humane type claim, however, all of these humane claims appeared closely in the context of Butterball's American Humane certification symbol. And NAD determined, as we discussed, since context is so important for these advertising claims, that given that they appeared closely to the symbol, the humane claims were modified, limited, and narrowed by their relationship to the certification. NAD held that when claims are made in close context to a third-party certification seal, the seal or logo itself serves to define or limit the claims, such that they only indicate compliance with that certifier's standards. So NAD held here that these humane claims, those of which appeared next to American Humane Certified's seal itself, meant that Butterball's humane practices comported with the humane practices required by this particular certifier, not that Butterball's humane practices were humane generally, or that they would meet every reasonable consumer's interpretation of the word humane. They were instead narrowed by context. So that's a pretty important point, and something that you'll see appear pretty frequently throughout these case examples, is that third-party certifiers, which we discussed previously, a certification seal will ensure that a consumer is taking away the more limited message that they're really only ensuring compliance with the certification standards itself. So AO's evidence was found not to be enough. AO attempted to argue that even if the claims at issue were modified or narrowed by reference to the American Humane seal, that Butterball's practices were not humane under any definition of the word, even in reference to the certifier itself. And they relied again on the investigations and on the FOIA documents that reveal poultry mistreatment at Butterball facilities. NAD held that this was not enough. So the investigations themselves predated the actual certification. So in this case, Butterball was not certified under American Humane when the investigations took place. So they said that these investigations were not relevant to analyzing the claims in context of the American Humane certification. And the FOIA documents, NAD was convinced that they didn't reveal a pattern or practice of deliberate animal mistreatment, but they revealed one-off exceptions due to extenuating circumstances. So you can see here that there is a higher burden for substantiation in cases where the certification seal is modifying or limiting the claims at issue. And in this context, the substantiation that Butterball presented was sufficient for NAD to determine that the claims at issue were not misleading. So however, one of the challenged general humane claims was not made close to the American Humane certification seal. Instead, it was made on a completely different web page, separate and removed from the seal or logo, not close to it at all. In this case, consumers could reasonably take away a broad and unsupported message about Butterball's animal welfare practices. So I think this is an important quote, and this really highlights the fact that NAD views animal welfare claims as meaningful and important to consumers and recognizes the value that consumers place on these types of claims and the particular harms that can result from humane washing. When presented without sufficient qualification, consumers could reasonably take away this broad and unsupported message that Butterball's practices are exceeding the humane practices conventional industry practices. Butterball also made what we'll call superlative animal welfare claims. So these are claims like best possible care for our turkeys. Does Butterball treat its turkeys humanely? Absolutely. Butterball continues to lead the industry in animal care. And superlative claims require a particularly high burden of substantiation at the NAD. So superlative claims, NAD held that consumers would reasonably take away the message, given this superlative and superiority language, that Butterball has one of the most rigorous, or the most rigorous, animal care programs amongst turkey producers. And in order to substantiate these claims, Butterball would have to produce evidence that was sufficient to show it had the most or among the most rigorous animal care programs. Generally, for industry-leading claims, NAD requires evidence showing that the advertiser is exceeding 85% of the relevant marketplace for the given attribute for which superiority is claimed. So in industry-leading claim, which is exactly what you see here, Butterball continues to lead the industry in animal care. Butterball would have had, in order to prove that this claim was non-misleading, would have had to present evidence that it was better than 85% of all other turkey producers in regards to its animal care practices. Butterball could not do this, and so the claims were found unsubstantiated. So here you can see that superlative claims in particular are not narrowed by certification seals. So the claim, the best possible care for our turkeys, it conveys a message that Butterball adheres to the best humane practices on the market, not that Butterball has met a particular certification standard. You can't argue that these claims are clarified in context because superiority claims are giving consumers the impression that you're exceeding the industry or you have among the best practices for the given attribute. So they are not modified by the certification seal at issue. Some of the environmental sustainability claims were also found unsubstantiated. We'll get a little bit into this in a few more minutes, but I don't think it's really necessary. Here, the ones that were found substantiated were claims that were couched in probably as close to puffery as you can get. It was things like, we are committed to our continued work to, very, very generalized and very non-outcome oriented, not specific. So those claims were found substantiated because they didn't really convey any message to consumers at all and therefore not actionable even at the NAD. So here's another case. This was a challenge brought by Animal Welfare Institute against Clemens Food Group and a subsidiary, Hatfield Pork Products. This case challenged a single express and single implied claim. The express claim was ethically raised by family farmers committed to a higher standard of care, governed by third-party animal welfare audits. And AWI argued that this meant that the pigs that are used to produce Hatfield pork products come from facilities that are using practices that are more ethical than conventional pig production. So NAD actually held that this claim was unsubstantiated, and there's a few reasons for this. The first, Hatfield attempted to argue because, again, these were pig meat products and the claims appeared directly on label. They had undergone mandatory USDA FSIS review. Therefore, they argued that the challenge was either preempted or that NAD should defer to the agency's determination. So here you can see NAD did not defer or hold that the claims were preempted. Instead, they found that they will look to a certain set of factors to determine whether federal agency mandatory review warrants preemption in a given challenge. Those factors include whether FSIS reviewed the challenge claims at issue based on consumer perception, and whether they explained their reasoning for doing so, whether FSIS specifically considered whether consumers would have been deceived by the challenge claim, and whether they explained their reasoning for doing so, and whether FSIS had the same consumer perception evidence in front of it that NAD does when observing these claims, and if that was useful in determining whether the claims were misleading or not. In this case, it was AWI had actually commissioned the survey at issue showing that this implied claim was that the Hatfield pork products come from pigs that are treated better than industry standard conventional practice. And so it was literally impossible that FSIS had considered the consumer perception evidence at issue because the survey was commissioned for the NAD challenge. What's also interesting here is that NAD found AWI's survey sufficiently reliable because it presented both open and closed-ended questions in a non-leading manner. Respondents were given options like neither, I don't know, I disagree. There was both a test, an experimental, and a control group present in the survey, and the survey polled nearly 400 individual respondents. Given the survey evidence and NAD's own independent conclusions on this issue, consumers could reasonably take away the implied message that AWI argued would come from this express claim. And Hatfield's substantiation, the evidence that they attempted to put forward to substantiate that they did in fact exceed industry practice, was insufficient to support either the express or implied claim at issue. So Hatfield argued that it was certified under the National Pork Board's PQA program and adhered to the common swine industry audit inspection criteria. But this evidence was not enough to substantiate the claims at issue because ultimately NAD determined that both the NPB and the PQA program, as well as the CSIA, were industry metrics. And so Clemens could not rely on industry metrics and the use of industry metrics to show that it exceeded industry standards in any meaningful way. Clemens did attempt to argue that the way it was using this industry metric exceeded industry standards, so they actually applied the CSIA more frequently than what the standards suggested. They participated in audits and inspections more frequently than what was recommended, but NAD held that wasn't sufficient either, because consumers are not taking away the message here based on the express claim and the implied claim that Clemens had exceeded industry standards, that they're just using industry metrics more frequently than other industry members would be. That was not enough to substantiate the claim that Clemens pigs were coming from facilities that were using better than conventional production. And again, loosely, NAD recognizing the value consumers place on these animal raising claims. There's some really great language in this decision that discusses the value that consumers place on these claims, the desire to align ethical decisions with preferential purchasing value, and the need for consumers to really not be misled when it regards animal welfare, because consumers can't understand or determine the truth of these types of claims for themselves. NAD finally held the one other piece of substantiation that Clemens attempted to put forward was a relationship with Dr. Temple Grandin. They held that this was not sufficient because it was actually not related to the claim that Clemens was making. Temple Grandin was not a third-party auditing program. She had helped develop the standards, but her participation in Clemens' practices, while they said does provide some evidence that Clemens does care about animal welfare, was not related to the substantiation necessary to talk about third-party animal welfare audits themselves. So, One Health certified. This was a challenge brought by ASPCA and challenger ARAC, based out of GWU, against a certification program, One Health certified. One Health certified is a certifier of chicken and potentially turkey products. I don't believe any turkey producers have as of yet been certified, but the standards do provide for turkey auditing programs. And OHC makes a number of express and implied claims. I'm going to go through these claims again as buckets because there's a ton of them. The first is the implied independence claim. One Health Initiative confusion claims, a bunch of animal welfare claims, antibiotic and environmental sustainability claims. So this case went both through the NAD and NARB, which affirmed the holding of NAD, so we're going to discuss them together. The independence claims, so challengers here argued that One Health Certified was not in fact an independent certification program because it was developed and led by the meat industry. The director of technical marketing for Mountaire, Dr. Donald Ritter, was in part the architect of some of these standards, and so challengers here argued that as a result of his involvement, as a result of industry stakeholder participation in the overarching body or standards review committee for One Health Certified, that this implied that this was not actually an independent certification scheme. NAD found that actually the independence claims were substantiated because based on the facts, Dr. Donald Ritter had retired and resigned from One Health Certified by the time the challenge was brought. So it wasn't a fair, they held it was not a fair characterization to say that he was still involved in the development of the standards creation process, especially since the standards were updated every 3 years according to the guidelines. And that while there was industry stakeholder involvement in the overarching standards oversight committee, there was also independent involvement from academics, nonprofit organizations, veterinary associations, and so that was enough to show that the certification itself was in fact independent. Challengers here also argued that the name One Health Certified, or the One Health Certified approach, which appeared throughout OHC's advertising, was itself deceptive because it implied conformity or affiliation with the One Health Initiative, which is a multi-sector approach that's designed to address issues of public health, animal welfare, environmental stewardship, and looks at all of these issues holistically. Challengers argue that this initiative has been in existence for a number of years, predated the OHC certification, and that OHC was attempting to borrow legitimacy from this existing program in order to sell its certification standards. NAD held that the One Health name and the One Health Initiative claims were in fact substantiated. They said there was essentially no evidence in the record that consumers in fact were deceived by the One Health name or that consumers were even aware of the One Health Initiative's existence. And so those claims were substantiated in this case. OHC also made a number of animal welfare claims, both in relation to the certification seal and throughout its advertising medium, online, YouTube videos, and through other advertising materials. And here we see a really great decision on the value, again, that consumers place on animal welfare claims and the potential deception from humanewashing. Broad, and here was NAD's language on this, broad unqualified animal welfare claims, like environmental benefit claims, are incredibly difficult to substantiate because they must be subject to multiple reasonable interpretations. Consumers can see a claim like responsible animal care and take a number of meanings away from that claim. All of which, again, must be supported because as we discussed, the burden for substantiation is placed firmly on the advertiser to support all of those claims, even the ones that it did not intend to convey. So in terms of the animal welfare claims, because this was a certifier, OHC attempted to argue that it had substantiated its animal welfare claims because it was exceeding industry standards in a few specific metrics. They pointed first to the systems-based approach that OHC uses, where the standards apply not at the individual animal level or not even, but at the farm level, which is a more systemic approach. OHC also argued that it has action thresholds. So there's numbers where producers must act in order to intervene and improve animal welfare that are not present in other certification standards. And challengers instead presented evidence of other animal welfare certifications. So they presented evidence of competing certifications that exceeded OHC in terms of animal welfare criteria. They also pointed out that OHC's certification standards themselves said that compliance with the NCC, the National Chicken Council, or National Turkey Guidelines, was enough in order to get certified. Challengers here were successful in arguing that those guidelines were ultimately, just as we saw in Hatfield, industry-based metrics. And so the fact that OHC standards said, if you comply with NCC, you've met our animal care requirements, was proof that OHC could not, in fact, be exceeding industry standards for animal care. And NAD agreed with challengers here. They held that certifications resonate powerfully with consumers because they provide an independent system, they look like a third party, and as such, in order for a certification to be meaningful, at minimum, a certifications must exceed industry standards for the given attribute that they are certifying. Here, the one metric that OHC was able to point to was not sufficient to prove that it exceeded industry standards. So these animal welfare claims that gave off the implied message that One Health certified was exceeding industry standards for animal care were unsubstantiated. OHC also made a number of superlative animal care claims, so things like best animal care practices, optimal outcomes for animals. NAD held here, as they did in Hatfield, that claims that resonate in superiority or superlative language must have substantiation that matches the breadth of the claim at issue. And OHC, because it wasn't able to prove that it exceeded industry standards for its animal welfare practices, could not provide the substantiation necessary to show that it exceeded at least 85% of the relevant industry for the claims for which it claimed superiority. Challengers here also argued that OHC's antibiotic claims were deceptive. So these included claims like responsible antibiotic use, reduce antibiotics to as little as possible for only as long as necessary. Some of these claims were found substantiated, but claims like responsible antibiotic use, NAD also held that such broad and generalized claims convey the implied message to consumers that OHC certified products exceed industry standards for responsible and judicious antibiotic use. Here, challengers presented evidence that both the turkey and the chicken industries had about half the industry was moving to a no antibiotics ever approach, so no antibiotics allowed throughout the growing cycle and life cycle of these chickens and turkeys, and that the other half was moving toward a judicious or reduced antibiotic approach. OHC's actual standards were not aligned even with the second approach, the approach that required a reduced or judicious antibiotic use standard. So in that case, NAD held that that was insufficient in order for OHC to substantiate these claims because they could not prove that they were exceeding industry practice for antibiotic restrictions. So the fact that OHC itself was even below the judicious antibiotic use, which is not a particular standard, it's just what the industry is moving to, made these claims deceptive. Challengers here also challenged a group of environmental sustainability claims. So these are claims like supports environmental stewardship, environmental impact. As we discussed before, NAD seeks to accord its decisions and harmonize its decisions with federal guidance. So challengers presented evidence of FTC guidance on the green guides, which provide guidance for industry and certifiers making environmental benefit claims. And the green guides specifically caution that an advertiser should not make a generalized environmental benefit claim because consumers can reasonably take away a number of messages. They're overall broad, they're subject to multiple interpretations, and every one of those reasonable interpretations must be supported. And given the breadth of general environmental benefit claims, it's almost impossible for producers to substantiate all reasonable interpretations of those claims. So in this case, NAD held that when a certifier is making an environmental sustainability claim, again, it must accord with FTC guidance, and it must also, if it in the context of a certification scheme, prove that it is at minimum exceeding industry standards. OHC's substantiation for its environmental benefit claims include reliance on its LCA, its life cycle analysis, as well as reliance on its waste management requirements. But challengers argued that these were not sufficient to substantiate the breadth of the claims at issue. And that was because while OHC standards allowed or required producers to track their their emissions through a life cycle analysis, it didn't actually require producers to meet a particular threshold for that given LCA. So a producer could have an LCA calculation that was through the roof, that was absolutely unsustainable, that consumers would take one look at and say this is not comport with what I would expect from environmental sustainability. And the fact that that producer was tracking and calculating the LCA, that was enough for certification. NAD held that merely tracking LCA is not what consumers would expect from these types of broad environmental benefit claims. OHC also attempted to argue here that the substantiation for these claims came from the fact that it had waste management procedures. But challengers pushed back on this and argued that the waste management procedures required by OHC were in fact just a line in their standards that said that OHC certified producers must comply with relevant local and state and federal laws related to waste management procedures. Challengers argued that a producer cannot substantiate general environmental benefit claims or prove that it exceeded industry standards for environmental sustainability when all that the standards required was that that producer comply with existing law. NARB affirmed this holding, and NAD ultimately concluded that those claims were not substantiated. So the last claim I want to discuss here is a specific type of animal care claim. I thought this was particularly interesting. OHC argued that OHC claimed that its standards required the prompt treatment of sick animals. So this is particularly interesting because the standards, in fact, did have action thresholds for when producers were required to provide individualized and treatment for sick animals, but they required a threshold number of deaths in order for the producer to act. So in order for a producer to provide treatment or be required to provide treatment under OHC certification standards, about 60 individual turkeys would have first had to have died. Challengers here argued that you can't make a claim of prompt treatment of sick animals if 60 birds have to die before you actually provide any treatment. That is by definition not prompt. And OHC attempted to argue that given the realities of industrial chicken farming, it was actually impossible for them to provide individualized treatment for every single chicken or turkey under their care. Instead, really, they had to work within these thresholds, just given the reality of industrial factory farming. Again, NAD ultimately agreed with challengers here, and that a claim that is literally false, a claim that cannot be substantiated because the practice of industry just doesn't allow for that claim to be true, should not be made, and the claim itself was unsubstantiated. So this case is, I think, the most recent case against an animal care certifier. The certifier was called Where Food Comes From, Inc., Care Certified. This was another challenge brought by Animal Welfare Institute against this particular certifier. Here, there was actually no express claim at issue aside from the certification seal itself. So Where Food Comes From, it's like a heart logo with a little circle around it that says Care Certified, and there was no other claim made than the certification seal that appeared directly on product packaging. AWI again commissioned another survey. They've been successful in this before, and argued that based on that survey evidence, the certification seal itself implies that care certified products and that the animals raised under the program are treated better than conventional industry standards. So here they really wanted to get the NAD to hold that this implied claim is true for certification programs, that if you're a certifier, you have to prove for that it's a given as implied even just by the seal itself and not additional express language like what we saw in OHC. OHC had a number of, again, those additional claims on top of the actual certification seal, things like responsible animal care, best animal care practices. Here, all we had was the certification seal. So AWI wanted to get to this holding that even just with the certification seal itself, you get away with this implied claim that consumers believe that the animals raised under the certification program are treated better than conventional practice. So NAD actually agreed with them. They found that the survey was sufficiently reliable and that the survey did in fact show that the care certification seal by itself communicates this message that a certifier must exceed industry standards for animal welfare. So this is really interesting because there, again, no express claims, no other claims made other than the seal. But the seal itself was sufficient to require this substantiation for an implied superiority message, or at the very least, a superiority message that you exceeded industry standards. But what happened here is that even though NAD did agree that the implied claim was a reasonable takeaway from the certification seal, they held Where Food Comes From, Inc. Had substantiated the claims at issue and that it had provided enough evidence to prove that it actually did in fact exceed industry standards. So this is kind of interesting. What evidence did CARE Certified provide in order to substantiate this implied message? They had worker training on cattle handling, healthcare oversight, continuous access to water for pigs that were certified, auditing, third-party auditing and verification, annual caretaker training, animal care policy, care for orphan calves and piglets, predator control, and traceability. For those of you who are familiar with other types of animal care certifications, you'll take a look at these and realize that these types of requirements are baked into almost every other animal care certification program. And this is what AWI attempted to argue. They created actually a multi-page chart that showed where CARE fell along the lines of other animal care certification programs, and they said, while there are some measures within this program that perhaps are different than other programs, there are animal care certification programs out there that are doing significantly more than what CARE Certified is doing. But NAD held that that's not what CARE Certified had to prove. While NAD did find that mere auditing is not enough to support an implied message that a certifier exceeds industry standards for the given attribute, they did hold that a verified and audited standard, so the auditing plus requirements between conventional industry standards and the highest standard, so a producer who's doing about 60% of the work to improve animal welfare, is not inherently misleading. So this is kind of interesting, and this does pose a little bit of an issue for future work against certifications, because while the certification scheme itself, the seal, the logo, whatever, is enough to create this implied superiority message, there is now a lower threshold for what a producer will have to provide in order to substantiate the claim that it does in fact exceed industry standards. So we know from OHC that a single measure or a single way in which a certification scheme exceeds industry standards is not enough in order to substantiate those claims, and we know now from CARE that auditing is not enough, but 3-4 points in a way a producer exceeds those standards might be sufficient in order for a certification seal itself to not be misleading. So I also want to talk about briefly another case that was before the NAD. This case is not a Humanewashing case, so it didn't challenge any animal care claims, any best animal care practices, superlative or otherwise. Instead, this is a greenwashing case. But it is against an animal agriculture producer. So JBS is the country's largest beef producer, and throughout their advertising, they make aspirational net zero by 2040 claims. Challenger here was IAGP, the Institute for Agricultural and Trade Policy, and they challenged variations of this net zero claim, which appeared throughout JBS's online advertising, in New York Times articles, in their sustainability reports. It was truly everywhere. These claims were found unsubstantiated, and this is a particularly interesting challenge because of how forward-looking the aspirational claims are. So we're 20 years out from when JBS would have had to prove that it did in fact achieve net zero emissions, and NAD still found that these claims require sufficient substantiation. So aspirational claims, just like concrete claims, particularly when they are tied to measurable outcomes, something like a net zero by 2040, measurable, zero, we can calculate that, create reasonably high expectations on the part of consumers and require significant evidence that the advertiser's efforts are providing environmental benefits with a very specific measurable outcome. So what steps did JBS attempt to argue it had taken in order to substantiate its net zero by 2040 marketing? It argued that it had taken It had invested in programs that were designed to research feed additives for how to reduce enteric emissions. It argued that it had funded significant research for how to reduce Scope 3 emissions from cattle farms. Really, a lot of JBS's substantiation in this case ultimately came down to funding. And challengers here are, all the while, JBS was expanding its operations. So JBS had grown in the time since making these net zero claims, which ultimately meant that its greenhouse gas emissions were increasing commensurately. Challenger here argued that given the size and scope of JBS's company and that the particularly strong message created by a net zero claim, which has support from the UN and other internationally recognized bodies, that the steps JBS took here, which really boiled down to funding and research obligations, were insufficient to support the 2040 by net zero by 2040 claims. So you had to provide, JBS would have had to provide evidence that it was actually taking steps that would lead to it achieving this goal by 2040, and mere funding was not enough to do that. So I thought this was a pretty hopeful case to end this presentation on and turn to questions, because it really shows the value, I think, that NAD places on humane washing and greenwashing generally, that it recognizes that these claims can create multiple interpretations in consumers and that they require a high substantiation burden, and that consumers are growing increasingly concerned with animal care and environmental sustainability, and that as such we have to treat this marketing as a real problem when it is deceptive and false. Thank you for your time, and I think we'll take some questions.
Thank you. We may have some questions online too, but.
Sure.
Yeah, thanks, Brooke. So I'm curious in terms of like outcomes, both, what are the best possible outcomes, what are the spectrum of outcomes, and any possible negative repercussions that we want to be conscious of. But I mean, broadly, it seems like one of the big outcomes here is getting them to change their labeling. Mm-hmm. Is there anything else, either tangible or intangible, that you see being productive from these conversations?
So I think we had touched on this a little bit. I totally agree. I think the main benefit from these NAD actions is that you get to stop the deceptive advertising at issue. It's really not a remedy that you can get through any other form of litigation, so that is a really special remedy here. I do think the other benefit is NAD will publish these decisions publicly. So in terms of consumer advocacy and really making sure that folks are more apprised of what's going on in factory farms, that they learn about the deception of humane washing and greenwashing cases, NAD makes these decisions largely public through press releases. So there is the opportunity for consumers to educate themselves about these cases, and especially with a company like JBS, a company like Clemens, these large nationally recognized brand names, I think it would give the folks that are purchasing animal products and like really trying to align their purchasing preferences with their ethical considerations pause and think maybe that this is an industry-wide practice, that there is a lot more deception going on that they realize, and maybe inform consciousness raising and advocacy moving forward. So I think those are the two primary benefits, or consumer awareness of these issues, particularly when NAD does quite a bit of work to make sure that these decisions get out there and to educate consumers, and stopping the deception at issue. There's really very few ways to do that, absent voluntary discontinuance of the claims through maybe communications with some of these companies, but often that's difficult to do because we know that these claims are profitable. We know that companies make more money when they make these claims and that consumers care about them. So nobody really wants to voluntarily stop making them because they'll lose a percentage of their market share based on consumers who care about animal welfare, consumers who care about sustainability, things like that.
The last case that you talked about, when they make a claim net zero by 2040, that sounds like they should have to demonstrate that they are actually making progress toward that result. It sounded to me, though, like you were saying that all they have to demonstrate is that they're taking steps that will lead to that result, as opposed to actually finding themselves moving toward it.
That's an interesting question. So I think what NAD held here is really that you do have to prove that you are taking sufficient steps and that what steps you have currently taken could lead you to a net zero by 2040, could in fact prove that you will achieve net zero emissions by 2040. I don't think they wanted to get into, to put myself into NAD's head, it's a very and technical laden argument. So I don't think they wanted to spell out exactly what would be sufficient here to substantiate a net zero claim, because ultimately NAD are marketing experts. They're not experts on greenhouse gas emissions. They don't know how, they wouldn't be able to advise JBS on how to actually reduce their emissions in order to comply with this claim. But what they did find, so they didn't really discuss a lot about what would be sufficient to substantiate a net zero claim. They did hold that a net zero claim is a really important claim with consumers and that it resonates particularly powerful in light of our current climate crisis, and that the substantiation that you would need for this claim would be pretty significant. So you would have to show that you are taking steps to that goal where it would be achievable at that stage. Again, I think this is acknowledging a bit of the forward-looking nature of these types of claims. JBS would not have had to say, would not have had to prove that it could in fact achieve net zero greenhouse gas emissions by tomorrow. But what it had done so far in order to substantiate this claim, the research it had funded, the studies that it was undergoing for its scope 3 emissions, those were not sufficient. So it had to be something more than funding. It had to be something more than just funding research, sending money to other organizations. They would have actually had to operationalize the changes in order to begin to reduce their greenhouse gas emissions. I'm not a science person, but I do know that IAGP, the challenger here, did some pretty significant work in calculating exactly what JBS's emissions are, and it would be a significant amount of work for them to achieve this goal by 2040. They would have had to start making rapid, deep emissions cuts now in order to achieve this aspirational goal. And NAD recognized that the science here was pretty compelling and that the steps that JBS had taken were not anywhere near what it would have had to have done.
That based more on like a case-by-case type of claim that's made, like a superior
That's a great question. I think it's both. So NAD applies a varying substantiation burden depending both on the type of claim. So if it's a superiority claim, then it requires a higher burden of substantiation. But it also, as mentioned, harmonizes its decisions with federal guidance. So there's certain federal guidance documents that NAD has looked at and said, okay, in these particular circumstances, given the definitions that FSIS has given us for animal raising claims and given the guidance from the Green Guides, which is a really comprehensive set of guidance on environmental marketing claims, that those claims in particular have already been recognized as very difficult to substantiate. So it's, I would say, category of claims, types of claims, the burden of substantiation varies across both of those. It also varies based on context, as we discussed. So if a claim is made in context of a certification seal, the burden of substantiation might be a little lower because the producer there would only have to prove compliance with the certification standards, assuming it wasn't making additional express claims in addition to the certification seal itself. And would really only, if the only claim at issue was that implied claim, then they would have to provide sufficient substantiation to show that it at minimum exceeds industry standards, but not that it's the best among the industry. That was the CARE case. So I think all of those factors change the level of substantiation, and that's really one of the benefits of an avenue like the NAD is they recognize that different advertising claims should require different forms of proof and different amounts of proof in order to substantiate, whereas in traditional litigation, it's I don't think you get quite as nuanced a perspective on what type of evidence an advertiser would have to put forward.
Go back to the standing slide. Yes, and thanks very much for this presentation. Super informative, comprehensive, and I'm encouraged the progress that's being made with these. frustrated by the traditional courts avenue and a little surprised as to why there's been such a roadblock here. So what you mentioned about standing, make much sense to me because there's injury redressability and problem.
It is a jurisdictional problem. So it depends on the jurisdiction, but the trend has been to hold that injunctive relief is not available in consumer class action cases based on deceptive or false advertising, specifically because there is no form of there is no risk of future injury. So that would be standing for injunctive relief specifically. But yes, the argument goes that because the consumer is now aware the claims are deceptive, which they know because they brought the lawsuit, thereby arguing they were deceptive, that they just can't be harmed again based on the same misrepresentations.
It sounds like a mootness argument, which is jurisdictional in my mind, and it sounds like it's not really a standing analysis.
Yeah, so it is interesting that it's viewed under standing, but there is a separate component of standing for injunctive relief in these cases, and courts do traditionally review it under the standing requirement and not under mootness. But I do take your point. That is a maybe a wrong step on the courts in these jurisdictions that have this particular holding. I think regardless of which doctrine it comes under, though, it's problematic in either direction because it still prevents any form of injunctive relief or discontinuance in these cases. Maybe it's a little better that it comes under standing than mootness since the whole case isn't dismissed.
Right.
It's just the particular claim for injunctive relief, so you would still be able to get monetary damages based on these cases. You would still ultimately be able to go to class certification even if you couldn't certify an injunctive relief class. So I think maybe it's good the courts didn't argue this under mootness for that reason, but I do take your point on that.
But I think drawing a parallel with environmental litigation, a lot of these strategic cases stymied with injunctive relief and damage.
So in the other forms of, so there is another avenue to seek injunctive relief here. It wouldn't be through the consumer class action remedy. It would be through the nonprofit actions that I touched a little bit on. So those are generally brought under the CPPA, DC specific statute, and that statute does provide for injunctive relief. So that is another alternative if the goal was to seek purely injunctive relief. The downside is it doesn't generally provide for damages. So you give up one or the other depending on which traditional vehicle you choose.
No, go ahead, please.
Thank you very much. You mentioned third-party certifications and auditing practices in a few slides and arguments. Given how the USDA doesn't have a lot of legal definitions for practices like cage-free, pasture-raised, things like that, these practices are beneficial for animal welfare and consumer protection and transparency, or are they becoming more of kind of like
I think bad certifications are particularly bad for humane washing because, like I said, they give this legitimacy to humane claims that perhaps like a producer making the claims for themselves wouldn't have. They give this illusion of independence, and consumers often aren't going into a particular certifier's standards to say, okay, what exact requirements do they have for animal welfare? Do they have for environmental sustainability? I mean, as attorneys, it's difficult to do that. These standards documents for all types of certifications can be 50 to 60 pages long, right? It's quite a bit of reading to do. And so I think, honestly, the truth is most consumers aren't able to like parse through that language or go through it and determine exactly what's going on with these certifiers. So the bad certifiers are probably some of the worst actors in the space for humane washing and greenwashing. That said, there are some truly wonderful certifications out there that do try to make incremental change for farmed animals who are living under these systems. They introduce standards that would reduce suffering and exploitation now for a lot of farmed animals, and I think those are incredibly worthwhile. Many of these cases where certifications were discussed, so One Health Certified, for example, challengers here are compared OHC to other animal care certifications that they argued actually did improve outcomes for farmed animals. So there were discussions of 5 or 6 other certification programs like Animal Welfare Approved, Made by a Greener World, which is a much more comprehensive standard, and drawing comparisons between what OHC standards allowed for in terms of animal welfare, or animal mistreatment, which was essentially conventional industry practice, and what other available certifications on the market allow for. I think it's also a necessary distinction because if a certifier is making superiority claims, you have to prove that they have to provide substantiation showing that they exceed 85% of the relevant marketplace. For a certifier, that relevant marketplace is other animal care certifications. So you have to prove that there are meaningful differences between your certification and another certification program. I think you also saw this in Where Food Comes From. AWI here preemptively, as I mentioned, introduced a massive spreadsheet that compared care certified across other animal care certifications. And I think for meaningful animal care certifications, there is a lot of room for incremental benefits to farmed animals, whether it's requiring increased space allowances, enrichment. I think there is a lot of room for at least for improvements to be made under our existing factory farm system that would reduce suffering now. And certifications are one way to do that.
I have questions, but I want to make sure. Are there any online questions? A couple maybe wonky questions.
Okay.
So when you mentioned that the consumer survey that was commissioned couldn't have been considered by FSIS, right? Because the commission. So now that it's before FSIS, is there a way to trigger another FSIS review? I don't know what that process is.
So the survey was put before NAD, not FSIS. I'm honestly not an expert on FSIS label approval. I do know that there are requirements for producers to resubmit applications periodically in order to resubstantiate the claims at issue. It's at minimum at least as often as like a given certification program if they're required to seek a certifier would
it seems
expire.
There's not a sort of an automatic pathway to get the data from NAD before FSIS. So they're going to be continuing without paying any attention to any of these court decisions or these consumer surveys.
I think this is a really good moment to discuss the fact that FSIS is currently updating its guidance for animal raising claims. We talked a little bit about the green guides. The green guides, not perfect, but compared to FSIS guidance on animal raising claims, the green guides cover environmental benefit claims. They're significantly more expansive, significantly more restrictive, and it recognizes truly the value that consumers place on this, the difficulty of substantiating them, and really the proliferation of greenwashing in 2023. There is an equivalent, but it is not equivalent for animal raising claims. Guidance for animal raising claims does not require nearly the amount of substantiation, and as mentioned, even though it exists, it's not always enforced. But there is an opportunity here because USDA FSIS is currently in the process of reviewing this guidance and updating it. And I'm hopeful that they will recognize that the fact that NAD itself has held that animal or humane washing claims are comparable to what they do to consumers and animals to greenwashing claims, that some of these decisions will influence the updated animal raising claims guidance. But for sure, if any of you are interested in things you could do right now to combat humane washing, it would be a great idea to reach out to your contacts at USDA, at FSIS, to encourage them to really make the guidance for animal raising claims much more stringent, to require significant substantiation, and to push them something closer to like what we have for environmental marketing claims.
Is there any effort to have the equivalent of the green guides for humane washing under the FTC?
Yeah, that would be a separate issue. So this, This goes to federal pre-approval, so that's really where humane claims or animal raising claims are reviewed, is the on-label representation. This, again, only on-label representations as it applies to poultry and other types of meat products, but it is one avenue to get there. So I think when we already have a process in place for mandatory review, and we just know that that review is one, under-enforced, and two, under-regulated and under-guidanced on the specific types of claims, that we should focus on like strengthening that avenue because it's already in existence. We don't need to reinvent the wheel. We know USDA is supposed to be reviewing these claims. We know that they have guidance. It's just not what is sufficient to prevent consumer deception. And so the work can be done to really improve what we already have, the structures that are already in place. Thanks, Kathy.
Yeah. So I was interested in when you said that NAD is basically telling people for environmental claims, general environmental claims, they basically shouldn't do that because consumers can be inundated. So I understood that correctly?
You're correct, yes.
Okay. So a couple questions that lead from that. So one, how many, do you have a sense of the body of cases that deal with environmental claims over the last, say, 15, 20 years? Because it seems to me that there are probably a lot of environmental lawyers too who don't know about NAD.
That's a great point, yeah. I think honestly, NAD has pivoted to focus quite a bit on these animal raising claims because advocates have forced them to. We brought this issue to their attention, but NAD has pretty significantly tried to situate itself as a mini FTC for these types of environmental marketing claims. They recognized for years that they resonate very powerfully with consumers, that they are subject to multiple different interpretations, and they're very, very difficult for a producer to substantiate when you say things like clean, sustainable. And I think there's a long history of NAD precedent recognizing both the value that consumers place on those claims and the difficulty that producers would have in substantiating them. So there's a very developed body of NAD case law on environmental marketing claims.
And so the reason I was asking that was to see if we were getting a comparable also make the statement that people should generalize animal welfare claims because they're also hard to substantiate.
So we do have that for certain generalized animal welfare claims. The difficulty here is that it's been cabined by a lot of these decisions, but NAD has recognized, I think we have this language in Butterfall and One Health certified as well, broad, unqualified animal welfare claims, just like environmental benefit claims, are difficult to substantiate for the same reason. It's because they're subject to multiple reasonable interpretations. One consumer viewing a humane messaging claim may think that it means the chickens who laid their eggs have access to insects and can forage, while another consumer might think that that means they have 24/7 outdoor access. Another consumer might think, okay, it can't be 24/7 because we need to bring the chickens inside if it gets cold. And that is kind of the problem with these generalized animal welfare claims. But NAD, at least in the language in the decision, seems to recognize that they are comparable to unqualified environmental benefit claims for the same reason. I think you get most of that in Butterball. For the one humane claim that was not found in close proximity to the American Humane Certified language. So here you go, you have very similar language in the context of a humane claim. This was the only claim at issue in Butterball where it wasn't presented sufficiently close to the certification seal, such that the claim itself meant that it was only complying with the certifier standards. But when the humane claim was presented on a completely different webpage, so away from the AH certification seal, on its own, I think it was on a page regarding antibiotic use, consumers could reasonably take away a broad, unsupported message about Butterball's animal welfare practices. So I do think we are starting to see the development